Welcome to the next instalment of HCR's Ask the Expert series. My name is Rachel Roberts and I'm a partner in the employment team. I've personally seen a significant rise in clients wanting help with business protection measures, particularly the drafting of post-termination restrictions, confidentiality clauses, and those related policies, such as those in the joyful world of social media. This is perhaps unsurprising given the current economic upheaval and the natural vulnerability this creates. This can increase the prospects of competition, whether from departing employees, team moves, or external competitors. Now, I'm joined today by Jenny Raymond, a partner in our dispute resolution team, together with her associate, Ian Seymour. Jenny and Ian both specialise in business protection and enforcement procedures. And I'm today going to throw some questions to get their expert thoughts. So I spend, as an employment lawyer, all this time with clients perfecting post-termination restrictions. And some of my clients query whether they actually offer the protection. Jenny, can a business really restrict a departing employee?
Thanks, Rachel. As employers, the starting position is that restrictive covenant in employment contracts are void. However, on the basis that restrictions are carefully tailored to the specific circumstances of the parties, they can be enforceable and they can protect your business and its confidential information getting into the hands of a competitor. They do need to be well considered, going no further than necessary to protect your legitimate business interests. If so, and based on our experience, they will be upheld and enforceable. Therefore, it's important just to give thought to the employee's seniority, consider limiting the restrictions geographically, and carefully consider the length of time that the employee is to be restricted. To that end, they do need to be bespoke, justifiable, and sufficiently narrow.
Great. So a client with a carefully tailored and reasonable restriction can be enforceable. That's good to know. So then, Ian, what can clients actually do when breaches happen?
Well, it's important to stress that the first step really an employer should be taking is to gather as much evidence as possible, because without the evidence, it's really difficult to pursue a claim at all. Once you've got that evidence, you'd then be in a position to send a letter of claim to the employee, and that letter will refer back to the employee's employment contract, highlighting their restrictions and pointing out steps that they might have taken in breach of those restrictions, maybe confidential information they might have taken. And we'd also normally, if it's appropriate, recommend sending a letter to the employer as well, enclosing a copy of the letter to the employee, just to put the employer on notice of the steps the employee's taken. And actually then if the employer is aware of it or encouraging the employee, then they can also be found to be liable potentially. In those letters, we'd also seek undertakings from the employee. And undertakings are effectively promises that you ask the employee to make. So confirming they're not going to breach their restrictive covenants going forwards, that they'll hand back any confidential information, things like that. If they then don't comply with that letter of claim and the undertakings that are requested in it, then there's an option to go to court to seek an order for an injunction from the court. And effectively, that's an order that says that the employee and potentially the employer, if they're involved as well, that they need to take certain steps, again, a bit like the undertakings, but with a formal penal notice attached to them, which means that if they breach them, it's really serious. And they could ultimately end up going to jail if they breach the terms of the injunction. So it is quite a serious draconian measure. Separately, if there are concerns about confidential information, you might also consider obtaining a search and seizure order from the court, which is something else that we've had experience of dealing with quite a lot.
Yeah, and just to follow up from what Ian was saying there, and to give an example, we acted for a company decided to depart. Prior to her departure, she set up a competing business, and it became apparent when she handed back all of her company property that she deleted everything, which led to our client having significant concerns, and consequently we were successful in obtaining what was called a doorstep search, whereby we attended at her premises. She didn't know we were going to turn up, and we asked her to hand over her mobile phone, her laptop and her iPad, And then a computer expert was appointed by the court to review all of the information contained on that, take a copy, and then that was used as evidence against her when we proceeded through the courts.
Oh, that's really interesting, Jenny. So it sounds like not only had that client breached her restrictive covenants, but there are also concerns about her taking some of the confidential information. So are there any extra steps we should be considering to protect our clients' business information?
It's a good point, Rachel. And to that extent, there are implied duties in employment contracts whereby employees are not to use trade secrets. However, it's always sensible to look at some express provisions and actually set out in the employment contract what you mean by your confidential information and how you want to limit that getting into the hands of a competitor. And these clauses can also be enforced outside of the period of a restrictive covenant. So say, for example, you've got a restriction against an employee who's left soliciting your clients for, say, 6 months. If they've taken confidential information, you can look beyond that 6-month period and look to try and get that information back. So, for example, we've been recently acting for a company whereby employees departed coming up for 18 months ago, but it's recently become apparent that they'd run off reports prior to their departure containing all of the client lists, and they've waited until their restrictions have expired, but are now looking to use that information to gain a competitive advantage. So again, the benefit of the confidentiality provisions in the employment contract enable us to take steps.
That's good to know. Thank you, Jenny. Ian, one thing that I'm often asked, given the prevalence of social media these days, is what steps can a business take to protect themselves in this domain?
Yeah, social media is obviously becoming more and more prevalent now, and in the way businesses work, it's more and more important. And we've actually dealt with a number of cases recently concerning the ownership of LinkedIn connections. We acted for a recruitment company which had a social media policy in place, setting out certain provisions to do with who owns social media accounts, etc. And we took that to court and were able to successfully argue that the employer had database rights over LinkedIn connections that one of its ex-employees had generated whilst he was employed with our client. And the court was therefore able and prepared to say that those connections belonged to the employer and ordered that the employee should delete those connections, which is really important because it just stops that easy way of competing with the employer in terms of posting out to those connections after they've left the business. And it's particularly the case that the court's prepared to make this sort of order where perhaps the employer has paid for an extra enhanced LinkedIn account, things like that, where it's clear that there's investment from the employer's perspective. Practically speaking, if you're dealing with LinkedIn a lot in your business, you might want to consider asking an employee that joins the business to create a new account when they start, because then that's an easy way of separating the personal from the professional, if you like, and does make it easier if it needs to be challenged further down the line.
And that's a really practical step, isn't it? Asking them to create a new LinkedIn account. I think that could be really, really useful. Have you got any tips for any other practical steps our clients can take to limit the risk of employees breaching those restrictions or even stealing that confidential information?
Yeah, absolutely. It's important to think about things that you can do just to minimise the risk rather than having to react once you've got an issue. So practical steps you might think about taking are considering your employees and how much they need to have access to that confidential information. Do they really need access to all of your financial information to carry out their role, or can you lock that down, for example? Also think about devices people are using, particularly at the moment with more and more people working from home and logging in remotely. Think about access that people have that way and locking down perhaps laptops and not letting employees use personal mobile phones, because that's opening, again, mixing the personal with the professional there is not that helpful. So practical steps like that we'd recommend.
Yeah, and just to follow on from what Ian was saying, it's important, obviously, when employees are leaving the business to make sure that they hand over any company property, mobile phones, laptops, etc. We always would, an exit interview prior to their departure, sitting down and explaining to them the restrictions that remain in place post termination of their employment contract is always sensible. We'd always recommend as well that you mind servers, look at their email accounts, check whether they've been up to anything. More often than not, people aren't actually as clever as they think. We've quite often seen examples where employees have literally just forwarded things to a personal email account. Steps such as, like I say, monitoring their emails, checking what data they've been downloading prior to their departure is always quite helpful. In serious cases, we can also look to instruct forensic experts. They'll undertake deeper searches. As mentioned previously on another matter, they identified that actually everything had been returned to the company, but were able to restore really vital evidence in respect of that claim. And it's also one other step to consider is whether you want to reach out to your clients and contacts to see whether any contact has been made. Obviously, it's a difficult balancing act. Often clients don't want to get embroiled, but it's surprising how much you can learn on the grapevine as to what's been going on. And the other thing to sort of flag is it's really important in these types of cases that you act promptly. Delay is often a reason. If you were seeking to obtain an injunction from the court, the courts will look at whether or not you've taken prompt steps, whereas the longer, actually there's a serious risk here to your business.
Certainly, that's really useful. Well, thank you, Jenny. Thanks, Ian. We hope that has provided some food for thought. If any of this has prompted any thoughts or you have any specific issues, please do get in touch. Thank you and look forward to seeing you again soon.